Welcome to the deep dive. Today we're tackling a really significant piece of legislation in South Africa, the Property Practitioners Act, the PPA. It came fully online February 1st, 2022. And our mission here is, well, it's not just about reading out sections. We want to give you the real-world legal and practical takeaways from this act. So whether you're maybe prepping for exams, working in the industry, or even just looking to buy or sell property, this should give you a clear view of the rules governing things now.
Yeah, it's a fundamental shift. This act actually repealed the old law, the Estate Agency Affairs Act, which, believe it or not, dated back to 1976.
Wow, 1976, so this isn't just a tweak.
Not at all. It's a complete structural change. When it was signed back in 2019, the intention was pretty clear, sort of rebuild the regulatory landscape from the ground up.
And the why seems really baked into the text itself, doesn't it? The preamble talks about more than just, market rules. It mentions restoring dignity through property ownership, which it calls a basic constitutional right.
Exactly.
Yeah.
And it directly calls out the historically skewed patterns of property ownership in South Africa, particularly in the secondary property market.
So it's acknowledging past imbalances.
It explicitly does. The core idea underpinning the PPA is that transformation isn't just nice to have, it's a necessary intervention. It's designed to actively benefit historically disadvantaged individuals using regulation to drive social and economic change.
Okay, so let's get into the nuts and bolts. How did they structure this? Section 1 seems to redefine the whole industry and its regulator.
Right. First off, the old regulatory body, the Estate Agency Affairs Board, well, it continues, but it's got a new name and significantly more power. It's now the Property Practitioners Regulatory Authority, the PPRA.
PPRA. Got it. And its job?
It's broader now. I mean, yes, regulation is key, but its stated objectives explicitly include consumer protection, setting up education and training, handling licensing, and crucially, driving that transformation agenda we just mentioned. It's basically an executive body with a social mission now.
That leads us to probably the most critical definition. Who is a property practitioner under this act? Because it sounds like it's way beyond just the traditional estate agent.
Oh, absolutely. That's perhaps the biggest change on the ground. The definition is incredibly broad. Of course, it still covers your typical agent, someone selling, buying, letting, managing property.
The usual suspects.
Yes, but then it expands significantly. It now includes anyone who collects or receives money related to a lease. Think rental agents managing payments.
Okay, that makes sense.
But here's where it gets really interesting, especially for the financial side of things. It now ropes in people who provide, procure, or market financing for property deals.
Financing, so like bond brokers.
Exactly. Bond brokers, bridging finance providers. Many intermediaries involved in the money side of a transaction are now likely considered property practitioners. They need to be regulated under this act.
Hold on. So my local bond broker now needs an actual certificate from this PPRA to do their job.
That's the crux of it. Unless they fall under a specific exclusion, yes. The main exclusions are attorneys and candidate attorneys, because they have their own attorney's Fidelity Fund, and a private individual selling their own home, not as part of a business.
So if you're making a business out of facilitating property deals in almost any capacity,
you're probably a property practitioner and need to register. And that brings us to the mandatory license, the Fidelity Fund Certificate, or FFC.
The FFC, tell us about that.
This is absolutely central. The FFC is essentially your ticket to play. Every property practitioner needs to apply for one, get it, and keep it valid. It has to be renewed every 3 years.
And what if someone doesn't or lets it lapse?
The consequences are designed to be severe. Section 48 is crystal clear. No person or entity can act as a property practitioner without a valid FFC.
Okay, standard enough. Fines, maybe.
It goes much further than just fines. Section 48, subsection 4, states that if someone operates without that valid FFC, they have to immediately repay any amount they receive from that transaction.
Any amount. Wait, so let's say an unregistered broker handles a deal, earns maybe 50,000 Rand commission on a million Rand property. They don't just lose the commission.
They must repay the commission, yes, and potentially face claims for other amounts received related to that illegal activity. The idea is to make non-compliance financially crippling.
Wow, that's huge.
And to make sure this sticks, Section 56 puts the conveyancer on the hook, too. A conveyancer is prohibited from paying any remuneration or payment to a property practitioner unless they're presented with a valid FFC. And crucially, that FFC must have been valid during the transaction and still be valid on the date the payment is actually made.
So the payment process itself becomes a compliance checkpoint.
Exactly. It builds compliance right into the transaction flow.
Right, that makes sense. Let's shift gears a bit to Section 2, which seems focused on protecting the consumer. What are the key pillars here?
There are really three big ones: the Fidelity Fund, a new mandatory disclosure requirement, and very strict rules around trust money.
Okay, let's start with the fund. The Property Practitioners Fidelity Fund, or PPFF. Is this like an insurance policy for clients?
In a way, yes. It continues the function of the old fund. Its main purpose is to reimburse people, consumers who suffer a financial loss because of certain actions by a certified property practitioner.
What kind of actions trigger a payout?
Primarily, it's theft of trust money by the practitioner, or if the practitioner fails to follow the rules about handling trust accounts correctly, like not depositing funds properly.
And if something like that happens, is there a time limit for the consumer to claim?
Yes, there is. A claim has to be lodged with the PPRA within 3 years from when the event causing the loss actually happened or reasonably should have been discovered.
3 years. Okay. Now, you mentioned mandatory disclosure. This sounds like a big practical change for buyers and sellers. The mandatory disclosure form, MDF.
This is a really significant shift, yes. It moves away from the old buyer beware or caveat emptor principle to some extent. Section 67 is key here.
What does it say?
It says a property practitioner must not accept a mandate. Basically, they can't agree to sell or let a property unless the seller or the landlord gives them a fully completed and signed mandatory disclosure form.
And what's on this form?
It's a declaration from the seller or landlord about the condition of the property, listing all known defects or issues. Think leaking roofs, faulty wiring, structural problems, that sort of thing.
And this form gets attached to the actual sale or lease agreement?
It must be attached, yes. And the Act specifically states it forms an integral part of that agreement. It's not just a supplementary document. It's legally part of the deal.
Okay, here's the crucial question. What if the agent doesn't get it? Or the seller refuses and they proceed anyway? What's the legal fallout?
This is where the teeth are. If that MDF is not completed, signed, or attached to the agreement as required, the law interprets the agreement as if no defects or deficiencies were disclosed to the buyer or tenant.
So the property is legally presumed to be perfect.
Effectively, yes, in terms of disclosure. This puts enormous risk back onto the practitioner. If a hidden defect then emerges, the practitioner can be held liable by the consumer because they failed in their duty to ensure the disclosure happened correctly.
That really forces the agent's hand to ensure compliance, doesn't it? They can't just brush it aside to get the deal done.
Absolutely. It shifts the burden significantly. And the third pillar is about protecting the client's money, the trust account rules.
Right. Deposits and rental payments often go through the agent.
Precisely. So Section 54 mandates that practitioners must open and maintain separate trust accounts for client funds. Any trust money received must be deposited into that account promptly.
And what's the ultimate protection for that money if, say, the agency goes bankrupt?
This is critical. Section 54.12 provides a powerful legal safeguard. It states that any money held in that practitioner's trust account does not, under any circumstances, form part of the practitioner's personal or business assets.
So it's ring-fenced.
Completely. If the practitioner becomes insolvent or passes away, that trust money is protected. It can't be claimed by their creditors or become part of their deceased estate. It belongs to the client it was held for.
That's a huge comfort for consumers putting down large deposits. Okay, let's move to Section 3. You mentioned transformation as a core goal earlier. How does the Act actually try to achieve this?
Well, Chapter 4 is dedicated to it. It's not just aspirational language. It requires the PPRA to actively implement, monitor, and assess specific measures to promote a more inclusive property sector. The focus is squarely on increasing meaningful participation by historically disadvantaged individuals, or HDIs.
And does it put money behind this?
Yes, crucially. Section 21 mandates the creation of the Property Sector Transformation Fund. This isn't just a vague pot of money. It has defined goals.
Like what?
Its purpose is to provide finance for property ownership and development, specifically targeting HDIs, women, young people, and persons with disabilities entering or growing within the sector.
Are there specific programs mentioned?
Yes, the Act outlines some examples. There's a principalization program aimed at supporting Black-owned firms to become principals. There's also a regularization program designed to help HDIs who might have faced barriers due to past minor non-compliance issues get back into the sector properly. And support for work readiness, It's quite targeted.
So practical steps. And what about research? Is there a mechanism to understand the challenges better?
Yes, Section 2 establishes the Property Sector Research Center. Its job is to conduct research, often in partnership with universities or the National Research Foundation.
And what are they supposed to research?
The priorities are laid out, identifying the real barriers preventing HDIs from entering and succeeding in the sector, looking for patterns of discriminatory behavior, and understanding the impact of the rural-urban divide on property opportunities. The idea is to use data to guide the transformation fund and policy effectively.
Okay, shifting to enforcement. With all these new rules, how does the PPRA actually police the industry?
They have inspection powers. Section 24 allows the PPRA to appoint inspectors, and these inspectors are given the powers of a peace officer when performing their duties.
What does that mean in practice?
It means they have authority. Section 25 allows them, with proper identification, to enter and inspect any business premises, not private homes, but business premises during reasonable hours without needing a warrant, specifically to check for compliance with the Act.
So spot checks are possible?
Yes, it allows for proactive monitoring.
And what if someone wants to complain about a practitioner? What's the process? Is it straight to court?
No, the Act sets up its own dispute resolution pathway in Chapter 5, designed to be more accessible and quicker than the courts, hopefully.
How does it start?
A person, usually a consumer, lodges a formal complaint with the PPRA according to Section 28. The authority then assesses it. If it seems suitable, Section 29 allows them to refer the complaint to mediation.
Trying to find a resolution first.
Exactly. Mediation is encouraged as a first step for many types of disputes. It's less formal, quicker, potentially cheaper.
But what if mediation doesn't work, or the issue is really serious, like alleged theft?
Then it escalates. Section 30 provides for adjudication. The matter is referred to an independent adjudicator, who must be legally qualified. This is a more formal process.
And what power does this adjudicator have?
This is key. The adjudicator's final order has the same legal status as an order from a magistrate's court.
Wow, so it's binding and enforceable directly. You don't need to then go to court to get it enforced.
Correct. It bypasses that whole extra step. The adjudicator can impose fines, order compensation to the complainant, potentially up to 80% of any fine levied can be awarded directly to the person who suffered the loss. It makes justice potentially faster and more impactful for the consumer.
That sounds like a powerful mechanism. Finally, let's touch on ethics. Does the Act define unacceptable behavior?
It does. Section 62 outlines what it calls sanctionable conduct. This covers a range of things. Obvious ones are like failing to pay fees due to the authority or continuing with practices the minister has declared undesirable under Section 63.
Anything else significant in there?
Absolutely. Crucially, it explicitly includes discriminating against any consumer on grounds like race, gender, sex, pregnancy, marital status, sexual orientation, age, disability, religion, culture. The list is comprehensive, reflecting the Constitution. Discrimination is sanctionable conduct.
And there's one more restriction I recall about relationships between practitioners and other service providers, Section 58.
Yes, that's an important one for consumer choice. It specifically prohibits a property practitioner from forcing or unduly influencing a consumer to use a particular service provider for the transaction, like insisting they must use a specific conveyancing attorney or a certain home inspector, especially if there's some kind of kickback involved.
And the penalty for doing that?
If a practitioner breaches this rule, they forfeit their entire right to remuneration for that transaction. Not just a fine, they lose their commission or fee entirely. It's designed to break those potentially conflicted referral loops.
Okay, so let's try and pull this all together. This deep dive shows the PPA really shook things up. It massively widened the net of who counts as a practitioner, bringing in bond brokers and others.
Definitely. Big change
There, it created serious consumer protection tools, especially that mandatory disclosure form, the MDF, which seems to shift significant liability onto the practitioner if they don't get it right.
Huge practical impact, yes. And the protection for trust money is now much stronger legally, ring-fencing it from the practitioner's own finances.
So looking at the big picture.
Well, I think the PPA does more than just regulate how estate agents operate. It sets up a legal framework aimed squarely at driving social and economic reform within the property sector. It explicitly links your right to practice that FFC with compliance, ethical conduct, and contributing to transformation goals.
Which leaves us with a final thought, doesn't it? The Act created these specific tools, the Transformation Fund, the Research Center, to push for measurable change. Given that keeping your FFC is tied to the PPRA's overall mandate, including transformation, How quickly will these powerful new legal structures actually start shifting the needle? How fast will we see real change in the demographic and economic makeup of South Africa's property sector in the next few years?
That's the multi-billion rand question, isn't it? The Act provides the framework, but the implementation and the market's response will determine the pace of that reconstruction.
Yeah.
It's definitely legislation with ambition beyond just regulation.